Morning. Welcome to the House Judiciary Committee meeting. I hereby call this fourth meeting to order. Mr. Clerk, please call the roll.
Representative Banta.
Present.
Representative Baumann.
Present.
Representative Blanton.
Present.
Representative Burke.
Here.
Representative Dietz.
Here.
Representative Flannery.
Here.
Representative Griffey. Here. Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox. Representative Marzian. Representative Moser. Representative Nemus. Representative Petrie. Representative Roberts.
Here.
Representative Stevenson. Representative Whitaker.
Here.
Representative Williams.
Here.
Representative Wilson.
Here.
Vice Chair Decker. Chair Elliott.
I'm here, and we do have a quorum duly constituted to conduct business. We're not going to allow any standing today, so there is an overflow room in 169. So please take a seat or exit out of the room as I spill some coffee there. Do you have a? Always got to spill something, right? The first bill that we're going to take up is Senate Bill 73, and that is Senator Brandon Storm, who is also the chairman of the Senate Judiciary Committee. I'm sorry, Senate Bill 64. Senator Storm, please come forward. There we go. That's why I have to have a sippy cup lid typically. Good morning,
Morning,
Mr. Chairman. Good to see you. And I know there is a sub, so is there a motion? There's a motion and a second. All those in favor, please say aye. Aye. Those opposed, no. And the sub is adopted, and you may proceed and introduce your guests.
Thank you, Mr. Chairman, members of the committee. Brandon Storm, Senator of the 21st District.
Dalton Workman, Charter Communications.
Ryan Bates, Deputy Chief of Operations, Louisville Metro Police Department.
Thank you, Mr. Chairman and members of the committee. Thank you for allowing us to present to you Senate Bill 64. It's a copper theft prevention bill, and really it's about key infrastructure assets in the Commonwealth. And so I have with me two distinguished gentlemen who can explain the reason this legislation is so critical, but we want to make sure that everyone understands that the definitions here are very tight, and they are to address specific issues that are faced throughout the Commonwealth. And at this time, I turn it over to Mr. Workman.
Thank you, Senator Storm and Chairman Elliott, members of the committee. Appreciate the opportunity to speak in support of Senate Bill 64. As Senator Storm indicated, Senate Bill 64 is drafted to kind of help address the copper theft issue we're seeing across the state. I know this is not an issue that's new to our friends in law enforcement and prosecutors as well, but I do believe we're seeing a different kind of phase of copper theft now in the last few years as it impacts telecommunication services, as the Senate committee sub addresses other infrastructure as well. For our purposes, Charter Communications, our broadband service is not copper-based. We are fiber-based. However, when these bad actors are in search of copper, oftentimes they are cutting our fiber services, damaging our plant. In 2024 alone, we had almost 20.
There's a motion. Is there a second? There's a second. Is there you want to finish your statement, and then we'll see what we need to do at that point.
I've been around long enough to know if you get a motion, it's best to be quiet. So happy taking questions.
Is there any discussion? Representative Kulkarni.
Thank you, Chairman. I was just wondering if you could briefly go over what the changes in the sub were.
Yes, so the change in the sub is on page 2, line 8, and we just simply added electrical highway infrastructure into the definition of key infrastructure asset, and that goes primarily to the officer here to my right. He may be able to explain that if you need more justification as to why that was necessary.
That's okay. Thank you.
Is there anyone else seeking recognition? If not, Mr. Clerk, please call the roll.
Representative Banta.
Yes.
Representative Baumann.
Aye.
Representative Blanton.
Aye.
Representative Burke.
Aye.
Representative Decker. Representative Dietz.
Yes.
Representative Flannery. Representative Griffey.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox. Representative Marzian. Representative Moser.
Yes.
Representative Nemus. Representative Petrie. Representative Roberts.
Yes.
Representative Stevenson, Representative Whitaker,
Yes.
Representative Williams,
Yes.
Representative Wilson, Chair Elliott.
Aye. So with 14 yes votes and no votes, Senate Bill 64 as amended does pass the committee, and congratulations, Mr.
Thank you, Mr.
Chairman. Always good to see you.
Thank you. Thank you, committee.
Congratulations. The next item that we will take up is Senate Bill 73, an act relating to sexual extortion. Senator Julie Rocky Adams is the sponsor, and she's here, and welcome, and good morning to you. And if you would introduce yourself and any guests that you have, and then you can proceed.
I was worried I was going to be all by myself, but then my security blanket came with me.
We're not too mean here. So
I know.
you would have been
scary.
okay.
Okay, my name is Julie Rocky Adams, and I represent Senate District 36.
I'm Shannon Moody with Kentucky Youth Advocates.
Okay, you all have before you Senate Bill 73, and it is on sexual extortion. Sexual extortion is a form of exploitation that occurs when a person obtains sexually explicit images of an individual and threatens to release them unless their demands for money, sex, or sexual content are met. We all know that being a kid today is very different than when we grew up. Social media and technology have changed the way young people connect, but it's also opened the door to new dangers we never had to face. Sexual extortion is one of the most dangerous and rapidly growing crimes targeting our young people today. The FBI reports that sextortion is the fastest growing crime against children. It is calculated, it is cruel, and it thrives on fear and silence. So too many kids today are being manipulated into situations they don't know how to escape from, and too many families are left devastated, wondering how this happened to them. So this is why Senate Bill 73 is so important. The bill does three critical things. It strengthens our laws by making sexual extortion a felony. It empowers victims by giving them clear legal remedies to seek justice and recover damages from those that harm them. And it prioritizes prevention by requiring schools to educate students and parents about the warning signs and ensuring resources are visible and accessible. So based upon
So the motion is in there. I think I heard a second, multiple seconds. I'll allow you to finish your.
No,
okay.
I'm good.
Okay, wonderful, wonderful. Is there any discussion on the bill? If not, Mr. Clerk, please call the roll.
Representative Banta,
Yes.
Representative Bauman,
Aye.
Representative Blanton,
Aye.
Representative Burke,
Aye.
Representative Decker, Representative Dietz,
Yes.
Representative Flannery, Representative Griffey,
Aye.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox, Representative Marzian, Representative Moser,
Yes.
Representative Nemus, Representative Petrie, Representative Roberts,
Yes.
Representative Stevenson, Representative Whitaker,
Yes.
Representative Williams,
Yes.
Representative Wilson, Chair Elliott.
Aye. So Senate Bill 73 passes with 15 yes votes and no votes, and same should pass on the floor. Congratulations.
Thank you, committee. You all were not scary at all now. Thanks.
Thank you. We have to have some more training. So I do want to take a moment to recognize a guest out in the audience, County Attorney Joe Ross, who is the Logan County Attorney and also the president of the County Attorneys Association. So if everyone would make him feel welcome today. Thank you for being here. Does any other member have someone that they would like to recognize? Okay, so that's fine. The next item is House Bill 662, Representative John Blanton, an act relating to personally identifiable information. and there is a substitute, Representative Blanton. There's a motion. Is there a second? There is. All those in favor, aye. Aye. Those opposed, no. And the sub is adopted. And if you would introduce yourself, and then you can proceed.
Thank you, Mr. Chairman and members of the committee. Thank you for allowing me to be here this morning to present this piece of legislation to you. John Blanton, I represent the 92nd District. This bill deals with personal identifiable information and the protection of individuals, if you will, doxing. And two groups that we're talking about with the committee sub being added. One is judges, including federal and state judges. Now, there are federal laws that prevents the selling of data of personal information. What this does is it allows a judge to petition a state government or a government entity, think of DMV, voting records, those type things that may have their names, addresses, phone numbers, and it allows them to write and say, please don't release my information. Now, it also provides if that judge turns around and posts something that they've asked not to be released and they've posted it, then it voids that written request, okay? So this just protects their personal identification at the request. The onus is upon the judge to make that request to that government entity, not to request that. The second portion deals with releasing the name of medical examiners when they are signing off when a doctor has made a request for a procedure, and then the insurance company, they're reviewing it, and then they come back with a response. It allows the removal of their ID, which if I understand it right, is their DEA number. We've seen what happened up in, was that New York back in the summer with the insurance guy. Now, I will point this out and be up front. Okay, there is some questions of, well, will hospitals be able to know who actually is, if it's a denial, who denied it, and how do we address, who do we talk to? So I am working, and I'm committed to working with getting the proper language that addresses that and fixes that, where that we provide the protection, but the hospitals or doctors have access to that information, and I think you'll hear them speak here. But we're getting late in the game, so this is one step in the process. So all I'm asking is let's move it forward today, and they have my commitment to work on a floor amendment to have this ready to fix a solution so that we're protecting people's lives, but also making sure that the doctors and hospitals have access to the information they have. So that's what this bill does. I'd be happy to answer any questions.
There's a motion and a second. Thank you, Representative Blanton, for the very succinct presentation on the bill. Do you know if this affects in any way when someone is obviously denied certain types of coverage or care? Does it affect the appeals process at all by altering this information from the document? Is that implicated at all through this, or do you know?
Not to my understanding. Only the sharing of the number, the identification number.
Okay.
So,
okay. Is there any discussion, Representative Mosier?
Thank you, Mr. Chairman, and thank you, Representative Blanton, for that explanation. You addressed my concern about the public versus provider-facing information in terms of the signature on these denial letters. I think it's important to protect the identity publicly for the reasons that you stated, with the United CEO being murdered and you know, that public kind of doxing. Because though it's not necessary for that signature to be public necessarily, but it is necessary for the providers, as you stated, to be able to contact the medical director who signed the letter for an appeal. So I'm glad to hear that you are going to work on that, and that gives me comfort. So thank you.
Representative Flannery.
Thank you, Mr. Chairman. Representative Blanton, we've talked about this, and I appreciate your commitment to continue the conversation. I have looked at this committee sub. I think the concern is from the communication I've received from some local hospitals is that the physician in a hospital setting or the, I guess, treating provider, I think it's really important that they be able to do some sort of peer-to-peer review and know that they're talking to maybe a whoever the insurance company's provider or I guess medical officer is, that they know that they're competent in reviewing maybe in a certain type of specialty. And I understand the intent of this, but you also have insureds that sometimes may be wrongfully denied. And that's equally important to be sure that folks that need certain types of treatment can receive that. So I appreciate your commitment to continue to work through this. I will vote for this in committee, but I did want to, I guess, lodge and raise this concern that I think is very legitimate as we go through this process. Thank you.
Thank you. Any other members seeking recognition? Do we have a motion on the bill, or was there a motion on the sub? We do. So there is some discussion. Corey Meadows, if you would come forward from KMA, and you can please don't leave. Introduce yourself.
Sure.
Then
Thank you, Mr. Chairman, members of the committee. I'm Corey Meadows, Deputy Executive Vice President and Director of Advocacy for the Kentucky Medical Association. I'm going to be very brief because the questions that were asked and the answers that have already been given assures us that people are willing to work toward the original intent of this, which was to protect certain information from being revealed to the public, but allowing that information to still go forward in provider communications, which is a critical piece as a part of the appeals process. And so we know Representative Blanton very well. He's a man of his word. We accept his commitment and look forward to working with him on that.
Thank you, Mr. Meadows. And seeing no other discussion, Representative Burke.
My question is actually for you, Mr. Meadows. If we're able to succeed in making the adjustments that are necessary and only the provider community has access to this information, will there be some person within that provider community who would be, for lack of a better explanation, taking the role of sort of like an investigative role or a journalistic role in looking at patterns of denials? So that we don't find that there's one bad actor who's consistently denying things that otherwise would be approved.
Sure. Thank you, Representative Burke, for the question. And I think what you're kind of describing is an advocate, right? An advocate for patients. And we're proud to say that our physicians act on a daily basis to be advocates for their patients. And so that's why we feel like this, at least them getting this information, is absolutely critical. And yes, I think there is a larger question about administrative processes in the healthcare space and how that can be a barrier to care. And that's why we want to thank you all, the House, for passing 423 related to prior authorization reforms. That is a very case in point of some of the problems we're seeing, but you are taking action on that front. So we think those types of legislation can make a real difference, but our members will continue to be advocates on behalf of patients, and I hope that answers your question.
Thank you very much.
Thank you. Mr. Clerk, please call the roll.
Representative Banta?
Yes.
Representative Baumann?
Aye.
Representative Blanton?
Aye.
Representative Burke?
May I explain my pass vote?
Yes, please.
I love part 1. I believe that we can improve parts 2, 3, and 4, and 5. I look forward to talking with you more about that, on how we can do it. I want to ensure that patients are protected, and I thank you for bringing the bill.
Representative Decker? Representative Dietz?
Yes.
Representative Flannery? Yes. Representative Griffey?
Yes.
Representative Kulkarni?
Yes.
Representative Lewis?
Yes.
Representative Maddox?
Yes.
Representative Marzian? Representative Moser?
Yes.
Representative Nemus? Representative Petrie? Representative Roberts?
Yes.
Representative Stevenson? Representative Whitaker?
Yes.
Representative Williams?
Yes.
Representative Wilson? Yes. Chair Elliott?
Aye. So with 15 yes votes, no votes, and 1 pass vote, House Bill 662 does pass, and congratulations, Representative Blanton.
Thank you, Mr. Chairman, and thank you to members of the committee for allowing me to present today.
You're very welcome. So a bill for discussion only that we will hear now is House Bill 320, an act relating to controlled substances. Representative Kleins, if you would come forward, and I know you have some guests, and they could introduce themselves and for the record, and then you can proceed. Thank you.
Thank you, Mr. Chairman and committee members, for your time this morning. I am Mike Kleins, Kentucky State Representative, District 68. I'll let my guests introduce themselves.
Hi.
Let's hit the mic, please.
Hi, my name is Kelly Donnelly Help.
I'm Mark Guilfoyle, a lawyer with DBL Law.
Welcome and good morning to everyone.
All right. Good morning. So, Mr. Chairman, House Bill 320 creates a designated drug-free zone for hospitals. Drug-free zones are not a new concept, but new to hospitals. So when I was a principal and superintendent, we had drug-free zones throughout our schools, and House Bill 320 mirrors that statute. So I want to give Kelly an opportunity to share why we feel that drug-free zones are necessary for hospitals. Get your mic on. Very good.
Okay. I am a nurse, not a public speaker, so if you don't mind, I would like to read this to ensure I am able to share the importance of this bill. I have been a nurse at St. Elizabeth Healthcare in Northern Kentucky for 23 years. 3 of those years, I worked PRN at the Alcohol and Drug Treatment Center. Being a nurse is not only a career, but truly a vocation for me. It's who I am. Along with being a mother and wife, it is my God-given talent to care for people from all walks of life, whether it be an elderly patient with pneumonia, a patient diagnosed with a terminal illness, or a patient suffering from a drug addiction. I am here to care for each and every one of them with dignity and respect. I am honored to work for a Catholic healthcare ministry that encourages me to live out my vocation by providing compassionate care to people that we serve. A lot has changed in my time as a nurse. Many things for the better, but unfortunately not all of them. As you know, the opioid crisis began over a decade ago and has remained a pressing issue ever since. One significant concern is the growing presence of drugs even on our hospital grounds. I often care for those with substance use disorder. While under our care in the hospitals, patients are presented with a valuable opportunity where they can find support on their path to recovery and a healthier future. Hospitals should be a place of healing, where frontline healthcare workers can help these patients without risk of encountering illicit drugs being on patients or visitors. I would like to share some situations with you that occurred on my floor in the past year or so that this bill would deter from happening in the future. It is a practice at St. Elizabeth Healthcare that we inventory all patient belongings. During this process, on multiple occasions, we have found illicit drugs. One situation, we found meth in the amount so great that the police were called and trafficking charges were pressed. Another situation, while inventory patient belongings, the patient had turned over all prescription medication for inventory. It was when we inventoried his backpack full of clothing that we found Suboxone hidden in his clothes. A nurse also entered a patient's room, found the patient to be very drowsy. A bottle of Percocet was found, putting the patient at risk for us to give pain medication along with what he was taking. We've had 3 situations of patients and visitors using drugs in the hospital. A patient was found snorting drugs in the hospital bathroom. Staff easily could have touched the leftover remnants on the sink, resulting in harm. A patient's visitor was found shooting up in the bathroom. We performed a contraband search and found that the patient too had drugs on their body. Another incident, the patient was not involved, but their visitor was caught shooting up in the bathroom. I personally held a greeting card that had fentanyl inside. It was after visiting hours when a family member dropped this card off to be given to the patient. Here we are, selflessly providing care to a complete stranger, and our lives are now at risk. It was after this incident and those mentioned that I reached out to Representative Mike Kleins to share my idea and advocate for the development of such a law. This issue has been a growing concern for me and my colleagues. We need help. Our patients need help. It's time for legislation to protect hospital staff, patients, and visitors from the risks associated with exposure to street drugs. The bill will make it a criminal offense to traffic or possess a controlled substance on hospital property, making these actions a Class D felony and giving law enforcement a more consistent process to keep illicit drug activity out of our hospital facilities. Just like the safe environment we strive to create in our schools, we want hospitals to be a safe place where our frontline workers, patients, family, and visitors can be free of the fear or exposure to illicit drug trafficking and other activity. My employer, St. Louis Healthcare, continues to implement measures to enhance safety of associates, and I see this bill as one more way to enhance these efforts and throughout the Commonwealth. Once enacted into law, the goal is to deter patients, family, friends, and other visitors from bringing illicit drugs into the hospital by enforcing consequences for their actions. This law would not only protect hospital staff, but also help the patients pursue a healthy recovery and a healthier future. Staff across the healthcare system deserve to come to work each day feeling safe and secure to provide the best care without the need to police illicit activity. This bill would ensure that those who exploit our healthcare system and unlawfully possess or engage in other illegal drug activities face real consequences. House Bill 320 is about keeping our hospital communities safe.
Motion on the bill?
I understand. Unfortunately, I'm not going to recognize the motion because it's for discussion only, so I'll rule the motion out of order. But I do appreciate your support of the bill, and I appreciate your testimony. Mr. Guilfoyle, I don't know if you have any comments, but I would recognize you to do that.
Well, thank you. I'm here to answer questions.
Okay, wonderful. I do have a question. Do you think at some point, as bills go through kind of at times can go through a tortured process here in terms of the legislative process, the part of this that makes possession of a controlled substance a Class D felony on a hospital campus, is there any room to define that only as trafficking? Is there any room there, Representative Kleins, or not? I'm just trying to feel this out in terms of the severity of how we are looking at doing this type of activity on a hospital campus. Is there any room for that amendment or change in your mind?
Well, thank you, Mr. Chair. Are you saying then the unlawful possession kind of gets?
Well, what I'm saying is this would only apply to somebody who's actually trafficking on the campus. It sounds like the nurse's testimony, and I'm sorry, Miss Hop. I'm sorry if how do you pronounce Halp? I'm sorry, Miss Halp. It sounds like there are people your testimony. They're actually possessing and using the drugs in your experience, so they're not. The scenario I gave would not probably apply then because they're not actually trafficking on the campus. Right. So is it more of a possession issue than actually trafficking or not?
Yeah, I might take a stab at that, Representative.
Sure.
Okay. When you look at page 2 of the bill, Mr. Chairman, possession is already a Class D felony, but it's got some limits on it, as you can see in the existing language. So I think the thought here was to slightly enhance the penalty for possession of controlled substances on a hospital campus. So it's already a Class D felony to possess.
Depending on the quantity of the particular schedule.
Yeah, correct.
Yes.
That's right.
And so this would just
it's a slight enhancement, quite frankly, from our standpoint. It's not that big of a deal. But to create a new penalty for trafficking, we think is critically important because, and I do represent St. Elizabeth Healthcare with 5 locations in northern Kentucky. There are people selling drugs on our campuses to patients and others. So we've just got to eliminate that scourge. But I would say to your point on possession, it's a very slight enhancement from our perspective.
Okay. That helps a lot. Any other members with questions or comments? Representative Burke.
Thank you. I have 2 questions. First, I want to say I do support the idea that we need to do more and do better to protect the frontline workers who are serving our community so selflessly. My first question relates to the level of culpability that would exist for someone who's brought to the hospital who is not conscious. Someone who's overdosed very well could have substances on their person. You would almost have to assume that that's a possibility when they come in unconscious or having just been revived. Is that person also at this enhanced penalty level?
So I want to note that, when it comes to the prosecutor, there is prosecutor discretion, correct? So it would revolve around unlawful possession and trafficking. So there would have to be determination made if, depending on which schedule it is and if it's clearly unlawful or not unlawful. But yeah, there is a risk, and that's what makes hospitals messy, right? When you compare a drug-free zone to schools to a drug-free zone for hospitals, it does definitely make it a little messier. But we're in a situation where the epicenter of House Bill 320 is the campus, the staff, the patients, and not necessarily the people bringing the drugs onto the campus.
Thank you. My second question has to do with the Schedule 4 and 5 drugs. Schedule 5 is cough syrup with codeine. So obviously you're going to actually receive that at the hospital pharmacy. Is possession of that included for penalty, or is it only trafficking of that which would incur a penalty?
Well, I would go again on unlawful possession. And again, I mean, the schedules, I think all the schedules have some gray areas as far as it could be unlawful or lawful depending on how you acquired it. So I would just always go back to the unlawful possession.
Thank you.
Representative Maddox.
Thank you, Mr. Chairman. Chairman Elliott covered the vast majority of my question, but again, back to the possession. For the folks who are following at home, in this particular circumstance, possession doesn't just mean that you physically have something on your person. Yet I have the concern of exactly that circumstance. In other contexts, unlawful possession of these types of medication are easier to parse, but leaving that sort of thing up to a prosecutor's discretion would be problematic for me. And also, what about emergency circumstances? I think that this was touched on a little bit ago, but if someone's having a heart attack, I can guarantee you the last thing that is on their mind is, what do I have in my pockets? What does the person who is bringing me here have on their person? I mean, I can attest that can be the worst day of someone's life, and they may not be thinking, and I see in this proposal here where there could be signs posted, but again, I'm not taking the time to read signs that are posted if I'm on the worst day of my life seeking medical care. And so I would have a myriad of concerns about the way that this is currently constructed, even to the extent of someone that is visiting that may be lawfully prescribed a substance for pain management that they keep on their person to deal with chronic conditions that they have. So this is, to me, has a myriad of pitfalls that I hope that we can address. Thank you.
Representative Moser.
Thank you, Mr. Chairman. Thank you for bringing this proposal. I think that the idea is good, but I do think that we've all got some questions that probably need to be buttoned up a little bit. A lot of the questions that I had have been asked. You know, what do we do with a patient or their family member when they come into the emergency department, again, on the worst day of their life, or if they've overdosed, they're more likely than not going to have some drugs in their possession. So, I mean, I think that, you know, when we are dealing with people in the emergency room, maybe it should be handled differently. If it's active trafficking or active use in a bathroom, absolutely. But if someone comes in and they are in possession, I think that that's our moment, our opportunity to get someone into treatment or to help them. And so I think some of those questions have been asked. You know, you all can think about that and see how you want to deal with that. But what if a patient has drugs in their possession, they, need to be admitted to the hospital, and they willingly or voluntarily surrender drugs. They say, I have these, whether they're lawfully prescribed. I mean, if they're lawfully prescribed and they have them with them, I think there should be an exemption for that. But if they have drugs in their possession and they are willingly or voluntarily surrendering them to get help, again, do we have any leniency in terms of how that person is treated? I don't really want to prosecute that person. I want to get them into help.
In regards to some of that, we do inventory everyone's belongings. So they do give us their Percocet. It's the patients that don't give it and hide it, or the Suboxone. So they are in all their belongings are inventoried. They have the opportunity when they come to the floor to, if they have it on them, to give it to us. We document it. They sign a paper. We send it to pharmacy. It's stored down in our pharmacy and then sent back up at discharge.
May I ask a follow-up, please?
Yes, you may.
Thank you so much. That's a great answer. I appreciate that. I guess I'm going to parse that out a little bit in terms of buprenorphine and Suboxone. If someone comes in with that in their possession, oftentimes it's because they're not able to access treatment. I mean, buprenorphine is the treatment for opioid use disorder. And so, again, I would say that patient probably needs some counseling around, hey, you've got buprenorphine in your possession. What's going on here? I think that, again, I wouldn't automatically prosecute that person. I would offer assistance. So, thank you.
Representative Williams.
Thank you, Mr. Chairman. I probably got a unique perspective on this coming from a law enforcement background, and then I worked hospital security, supervised it. And I love all the answers of the rosy-filled glasses that everyone's wearing, that somebody just stumbles on the parking lot and they just so happen to have drugs on them. Most of the time, that's not the case. What I saw is a patient would come in and a visitor would come in and pass out their drugs to the patient, to their other visitors. And I think this is where we're targeting the audience here. And I was appalled to see the level of violence, the level of this kind of things in the hospital compared to law enforcement, that I would have arrested somebody a lot quicker. So I applaud the bill. I think it maybe could use a little tweaks, but I think that's an easy fix. And I appreciate you bringing it, and I fully support it. Do we have anybody else? Who else supports this bill?
So, thank you, Representative Williams. So it's supported by the KHA. I've had KNA members, so Kentucky Nurses Association members, come see me individually in my office to support it. The KNA as a whole was very interested, but they didn't have time to go through the process of endorsement. I've communicated with a retired prosecutor and a current prosecutor, and they were okay with it. I also communicated with the chief of police for Fort Thomas because of St. Elizabeth Hospital in Fort Thomas, and the chief of police in Edgewood because of the location in Edgewood. It is also endorsed by St. Elizabeth Hospital. I didn't speak with the KMA. I did see Corey here earlier. The Kentucky Justice Association, I've only heard indirectly, but it's not a concern of the Kentucky Justice Association. So I feel like we're in a really good process of vetting this bill, and I appreciate the chairman's letting us have an information session today and a Q&A. Again, I think the overall benefits of 320, we're going to support the staff, their well-being, and their protection. We are dealing with a very enhanced patient safety. They're very susceptible populations. I think it can ultimately improve health care outcomes because they're coming to this location to be healed, not to be exposed. I think it would reduce incidents of crime-related situations on the hospital like it did in schools, and there is research to support that. Also, I think there's a community trust and awareness program here. You know, you can say a sign's a sign, but there's either one up or there's one not. And if there's not, it's not going to do anything. But if there is, as you pull into the campus, as you go into registration, as you're sitting in the lobby, as you're sitting in the cafeteria, and various waiting rooms, you have these signs that say, we're serious. We mean business. You know, we have, and you can help me with this, how many employees on these 5 campuses in St. East, and I'm talking about the Commonwealth, across the Commonwealth of Kentucky, that we as a Commonwealth are unilaterally or statewide saying enough's enough. Enough's enough. I'm not flipping anything upside down when it comes to the KHA or the KMA or any of that. I'm just saying, hey, you're getting put on notice. And if, you know, we don't live in a black and white world. I know that. I was in education. I had students come to me all the time with discipline situations. It says in the handbook it's a 3-day suspension. Well, maybe I gave them a 1 day. Maybe I gave them a 1 day. Okay, so it intensifies the awareness among the employees. And we also, I think it deters theft. Okay, so we have a theft problem in our hospitals. So what if we catch an employee with unlawful possession of these drugs that he or she stole from the hospital? Well, now we have a policy that we can fall back on. So, you know, we can do as is. We can say, you're adults, these were kids. We're trying to protect the kids. We're not trying to protect the adults as much. But that's not fair. It's not fair to Kelly, and it's not fair to any of our health care employees. And we do have a nurses shortage. And they say, what are you doing? What are you doing to help my safety? I'm here to protect everybody else. Same way with teachers. I'm here to help. But what are you doing to help me? And this is a way that we can help them. So again, I pontificated a little bit, Chairman Elliott, so I do appreciate your indulging me. Is there anything final that you would like to say, Kelly or Mark?
The only thing I would say, just going forward, Mr. Chairman, is I didn't hear any questions about Section 1 of the bill, trafficking, and that is a mirror image of KRS 218A.1411, which is the same rule for schools. The questions are all about Section 2 of the bill.
Yes.
So if there's any way to move ahead with Section 1, you know, that would be a major statement. I don't know if that's possible procedurally, but
I appreciate
just a thought. Just a thought.
And I think it's very well taken. You know, I think back during the pandemic and how difficult that was for everyone, and our healthcare workers were on the front lines of those hospitals working hard every day, and we really didn't know a lot of what COVID could do to you at that time. We didn't have a vaccine, so we appreciate our healthcare workers, and I appreciate you, Representative Kleins, for trying to do everything that you can to protect our healthcare heroes. We do have some more discussion. Representative Roberts.
So I do have a question regarding Section 1 on this. For one, thank you to the sponsor. Thank you to you guys for the work you guys have put into this bill. My concern is getting into that inventory issue where you're on the hospital grounds before that inventory occurs. And if we go to KRS 218A.010 subsection 56, that's where the definition of trafficking for that chapter is. It mentions possession with intent to distribute, and courts have interpreted it to where if you possess above a specific quantity, that creates a presumption of intent to distribute. And for individuals who are selling drugs, using drugs on hospital grounds, absolutely, this is something that needs to be immediately addressed. But my concern does come from what several members have mentioned of individuals who have overdosed, who have been in accidents that have rendered them incapable of making decisions, or they're rushing to the hospital. They can't really just drop these items. And I'm just thinking like that I think the screws need to be tightened a little bit just to make clear, because I think this is a clear problem, but I think it's a problem that more warrants a scalpel than a sledgehammer, where I don't want people to go to jail because they're going to the hospital and they just have narcotics above a certain quantity under this section. I'm just wondering if there would be openness to narrowing language. This is an issue that is near to my heart. I lost my father to addiction when I was 6 years old. And I can say, we as a government failed to intervene in his story. And there's so many other people that we have failed to intervene on, where turning it into a criminal issue for those who desperately need help, I don't think that's helped particularly. I think it's something that we need faith, we need healthcare, we need the communities uniting to get these people the help that they need. And I just want to make sure that when we move something along these lines, that it's a little narrow to ensure that if you're coming for help, or that if you are incapacitated, that you're not fearful to go to a medical center to get the help that you need. I just wanted to see if there was any opening to doing something along those lines, just to make clear that the inventory is not going to be the grounds for prosecution.
So, one of the things, so when they come in, we do the admission history. We are finding out if they do have a drug or alcohol problem. They are then, they get a chemical dependency educator comes to see them. At that time, they have the opportunity to hand over any drugs that they have. We ask them if they have any of those sort of things. So I think some of, people coming for help, they have the opportunity for the help. It's when they keep this on them and hide it from us that is our biggest problem. So,
And Representative, I would just say that the definition that you reference, intent, is the second prong of the element. So someone who's in a parking lot who has a lot of drugs on their possession, that in and of itself is not trafficking. You'd also have to prove they have the intent to sell or distribute. So I don't think that Section 1 would be a barrier to what you're describing. But to narrow it into focus, that I think Representative Kleins is not going to let this go, so there will have to be some fine-tuning here.
Yeah. Thank you, guys.
He's very tenacious. Representative Kulkarni.
Thank you, Chairman, and I appreciate you bringing this bill for discussion only, right? So this is how a well-intentioned piece of legislation becomes good law. So I appreciate the thoughtful discussion and your openness to listening to our concerns. I, of course, share a lot of the concerns that my colleagues have raised, specifically with regard to language and the need to make it less broad. I mean, you're sitting in front of a bunch of lawyers, so words matter, terms matter, right? What possession with intent to distribute, trafficking, all come with different levels and different penalties. And the concerns that I will raise just specifically about language is you're talking about Schedule 1 through 5. You're talking about differences in what constitutes possession with intent to distribute, or trafficking, depending on what the substance is. They're not across the board. I think that needs to be included. So whether it's amounts or something that will comport with our existing statutes and regulations and penalties. And the other thing I will raise is this idea, we've talked about emergencies and how broadly this might apply. I agree with Representative Maddox that, prosecutorial discretion is a great tool, but they also will probably appreciate very specific language in terms of the parameters that they are able to operate within. But in Section 1, Sub 2, it says any person. Now, we're surrounded by states where quantities of cannabis are legal, for instance. So any person under this bill could mean someone who's driving through, gets in a car accident, and would be prosecutable under this particular draft. So I worry that we are not looking at this narrowly enough to, I think, accomplish the intent that you are seeking to accomplish without adding all kinds of unintended consequences and ramifications. So I think your openness to work with us on some of this language and tightening it up will be beneficial to achieving that outcome. So I appreciate your time, but those are some specific concerns that I had. Thank you.
Thank you. And the final member with a question, and then I'm going to recognize Scott West, who is going to speak, looks like in support of House Bill 320. Representative Wilson, you're recognized.
Yes, I try not to speak, but so much discussion, I'm surprised nobody's brought up the point. The conduct I've heard described is already illegal. It's already trafficking. It's already possession. Have you had trouble getting charges brought or indictments? I don't understand it making it more illegal. It's already illegal, I guess. Are you having trouble with that? Can you help me understand that?
I would just say under Section 2, we're enhancing the penalty for possession on a hospital campus. And there is no crime currently for trafficking on a hospital campus.
Well, there is. It's called trafficking.
Well, trafficking
of a controlled substance.
Yeah.
So you can get charged with that trafficking anywhere if you're doing it here or school, hospital,
but there's a separate
Walmart.
Yeah. It's defined a little bit differently, Representative, in Section 1 that the general trafficking law is about all I can say on that. And there's a specific law for schools on trafficking that's also an enhancement over what basic trafficking is.
So have you all been having trouble getting charges on the under current law?
I don't know that we could say that. What we're saying is what Kelly is describing is an immense problem day to day just doing her job. That's where the problem is.
And I think what this would also do, Representative, would be bring a consistent approach to every hospital throughout the Commonwealth, to where maybe a security guard, and this is just presumptuous, okay, so maybe a security guard takes it and throws it in the garbage can. Says, oh, this is who we deal with, and you're going to have to live with it. Or another one takes them to the full extent of the law. So I think what this would help with is consistency for everyone to be able to fall back on a policy, and that would be our ultimate goal. So is it happening? I think the way it's being addressed is what's inconsistent. And again, I don't work in a hospital daily, and that's just what I'm sensing. Okay.
That makes sense. Thank you.
Thank you, and I'll thank you all for your presence today in the discussion, and I'll recognize Scott West to come up. And I think, Scott, I'm reading that you have some concerns. I had issues reading that handwriting, so I'm sorry. I had a very strict penmanship teacher in grade school, so I still remember those days. But go ahead, Scott. Thank you.
And I apologize for the penmanship. I am Scott West. I'm here for the Kentucky Association of Criminal Defense Lawyers. And I do have concerns which were largely addressed by Representatives Burke and Representative Maddox, Representative Moser, and Representative Williams. So rather than rehash that, I would offer what I think is a fix, and that is unlawful possession and intentionally introducing onto a hospital campus, or intentionally concealing upon being requested to surrender any unlawfully possessed drugs. I think what that would do is the person who has a heart attack at Reparina or is pulled from a car on Broadway and gets rushed to UK and they don't even know they have it on there, well, they didn't intentionally introduce it. But therefore, they would not have the full penalty of the big D. It'd still be possession of a Class D felony. It would just be the one that would apply if they never went to the hospital. They were just arrested in Reparina or just arrested on the street after an accident. And I think that would be fair because they're not intentionally trying to bring it onto a hospital. And I think that would fix it. The other thing I'm concerned about is the way the hospital is defined to include chemical dependency treatment facilities and rehabilitation hospitals. And my concern there is people who are chemically, psychologically, physically addicted to drugs and are in a chemical dependency place, they're right where they need to be. And because they're still there, they haven't yet developed the tools to combat the addiction when they're out. Hopefully they're going to develop those tools. Hopefully they're going to get whatever they need so that they can manage their addiction once they're released. My concern is someone who is the object of this bill, the person who says, oh my goodness, 6 of my best customers are in rehab. I've got to do something. And they smuggle them pills in there. And then what happens is the person who's fighting addiction and trying not to use finds himself in possession of things and they can't help themselves because they're not there yet. Even the most successful rehabilitated people are often in a 2 steps forward, 1 step back, 3 steps forward, 1 step back, and they're on the road to recovery. And I would hate to see this bill be a disruption to that because somebody else took advantage of the situation where they really aren't in a position inside where they can say no to a drug. And so I would ask that that be addressed in such a way that, you know, I've been to many drug courts, and very often you have someone who has a non-clean screen of their urine. They don't get revoked, they don't get charged, even though they would have had to have possessed to have used. They get a sanction if they are on the path to recovery. And so I would say if there's anybody in these hospital settings who are on the path to recovery and they're making forward progress, please don't let this be the vehicle that ends that for them and puts them right back to square one and back in the prison setting where they're not going to get necessarily the same level of attention that they're getting at a rehab facility. And those are my comments, and thank you as always for letting me speak.
Thank you, Scott. It's always insightful. We appreciate it. Thank you, members, for your indulgence today. I promise not to spill any coffee next week. So if there's no other business to come before the
Mr. Chairman,
committee. Yes.
May I register 2 votes, please?
Yes, you may.
I would like to register a yes vote on Senate Bill 64 as well as Senate Bill 73, please.
Those are recorded. Thank
Thank
you
you.
very much. We'll stand adjourned.